Any mention?
My lord, I beg to mention item number 15, 16 and 17, my lord. All are connected matters.
All are?
Connected matters, my lord. 15, 16, 17. My lord, if the matter may come after 2 weeks, my lord.
Mr. Padi is not there?
Not available, my lord.
No
Yes.
objection.
Yes, after 2 weeks.
Highly obliged.
25 matters, yes. Yes.
Please, Your Lordship. Lordship, I beg to mention item number 13.
Number?
13.
Sepal and Marak.
Yes, Your Lordship.
No objection.
Lordship, I pray for 2 weeks' time.
For?
2 weeks' time.
No objection?
No objection, Your Lordship.
Yes. Yes.
Obliged.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 11, Your Lordship. Pray for 2 weeks accommodation, Your Lordship.
What's the matter about?
This is a matter with regards to the bifurcation of the village, Your Lordship.
Your for respondent number?
Respondent number 6, Your Lordship.
Number 6.
Yes, Your Lordship.
What about who are the main respondents? HEDC. That you told them?
No, Your Lordship, actually.
We informed them.
All right.
Yes, 2 weeks, yes.
Much obliged, Your Lordship.
Please, Your Lordship. Lordship, I would like to insist item number 10.
Yes.
Kindly this matter may be taken up after 1 week, Lordship.
Other side, who's there? You informed them?
No, Lordship.
You informed them?
Yes, Lordship.
Then you informed them 2 weeks.
1 week, Lordship.
You informed them, otherwise Pala called, where's MS Kolni? Yes? S. Sham, R. Gurung, S. Sen, J. Thaba, H. Karmi, E.R. Khan, all the entire army of panel advocates are here.
No objection.
No one's appearing, yes?
Your Lordship, I was just informed, Your Lordship, to appear on behalf of Mr.
You're the only one whose name is not here.
Yes.
Whose name is here? Yes, by Mr. Gurung.
Yes, Your Lordship.
No objection? Yes.
Obliged, Lordship.
Obliged, Lordship.
Should I beg to mention item 12? Mr. Chanda is not available.
You're there.
After 2 weeks.
Yeah, I said you're there.
I'm there, Lordship. If
Then?
after 2 weeks.
Yes.
Obliged.
May I see?
Supplementary list item number 1.
Samantha, with adjourn the matter since you were not here yesterday.
Yes, sir.
Yes. No, he's there. Yes.
Lord, the issue in this case, Lord, in the requisition is very limited one. I applied for grant of sanction to renew the building permission and to grant me permission to build my house, Lord, in the cantonment board. And it has got long and checkered history, my Lord. Initially, my Lord, I had a lot of difficulty in getting my bungalow. If your Lordship will kindly come to page 150. First expedition, when I succeeded, my Lord, is at page 144. At 150 is the direction input by. And then your Lordship directed.
Yes.
Paragraph 14 at page 151.
14.
14 at page 151. This is the order passed by your Lordship, this Honorable Court on 28th April 2005. For the aforesaid reasons, the court is of the opinion that if petition succeeds and accordingly it is allowed, the respondent, particularly respondent 2 and 3 are directed to vacate the said premises and hand over the vacant premises of the same to Krishna within 30 days from the date of receipt of the judgment order. District Commissioner is cardiologist to directly ensure that premises is handed over to Krishna within the appropriate period of 30 days, considering the facts and circumstances. And thereafter, the building was handed over to me. And at page 153, page 153, I received the possession of the house, at 153. That building was handed over to me on 31st May 2005. I moved the application, my Lord, before the cantonment board on 17th September 2005, my Lord. for renovation of bungalow and for building plan, my lord. That was on 27th September 2005, my lord. Nothing was done, my lord. Ultimately, I came before your lordship, and then your lordship issued direction on page 211 in the year 2017, my lord.
Yes.
Because my matter was pending, and then you also at page 215. The direction was issued to the appellate board to decide the appeal expeditiously, because board has not been approving my sanction plan of 215. So then the lordship directed appellate authority also for the director to dispose of the matter expeditiously as soon as possible according to the rejection stands dismissed. So the direction was to the board to decide my appeal expeditiously, and the decision may not, your lordship will find at page 246 and relevant page is 255.
255.
255, paragraph 11. In view of the above, the following directions and orders are passed, the applicant is given a fresh notice of re-erection of bungalow number 33 under section 235 of Cantonment Code, together with complete building plans and sketches, details of material to be used, as well as detailed cost estimate of such re-erection to the Cantonment Code, challenged within 1 month from the date of receipt of the order. Applicants have rendered an affidavit of undertaking regarding effective erection of re-erection of said bungalow on survey number so and so at reasonable cost as per its original specification, character of the sound and reading the full change area and cubic capacity of each room and where it existed for its demolition by the applicants. The undertakings are also stated that shall cooperate in peaceful resumption of the leasehold property after expiration of the lease in 2026 to Government of India without seeking any compensation for expenditure done by applicant. The Cantonment Board shall process the case of necessary NOC by CEO Guwahati Cantonment Board, and the lastly, the Cantonment Board shall consider the violation, etc. This was the I succeeded in the appeal, and then I.
One second, the bungalow standing or demolished?
No, they are deflated condition.
They have demolished.
Deflated condition.
Demolished or standing?
They have demolished that.
Partly structure is standing, my lord. There was a workers' house we had made which was demolished.
For erection, only for repair?
Erection, my lord.
For erection?
Re-erection.
That means okay.
This was the permission granted to us by the appellate authority and went to the board in terms of the direction by the appellate authority, which you will also find at page 451. At relevant 451, 451, 451.
451. Yes.
451 at page 454, you will also find the decision of the board which is non-speaking, no reasons, and it has been rejected without giving any reason. You will also find the resolution of the board at the foot of the page of page 459.
Rejected the building application.
Yes, my lord.
Which date is this?
The matter was widely deliberated by the board. The board took note of the stay order in execution proceeding in Guwahati High Court communicated by TO White so and so, letter number so and so. 3. Parasmal Botra, elected member is of the view that sanction is to be issued with conditions keeping in view the order of the appellate authority on 26 November 2018. The board finally considered and rejected the building application. So this is all what has been communicated despite clear, categorical and unequivocal direction by the appellate board to consider me. After this, because we felt that in the case of contempt of the order, we went to court with the lordship in contempt. This order, my lord, of the board was placed before the in contempt jurisdiction at page 457, my lord. 457.
No, this order was passed when this rejection?
This order was passed way back, my lord, in 10th October 2019.
This rejection order? This page 454?
That rejection order.
2019?
2019, my lord, 2019. There is some checkered history, my lord.
But why, but now it's 6 years down the line.
2025, my lord. 6 years, my lord. That is the delay which I am trying to explain, my lord. 4, 5, 6. So, what has happened is this order was not communicated to me and I find the contempt at 456, my lord.
This 2019 only, yes.
Yes, my lord, 419 only. 19, my lord, I find contempt, the court said contempt is not made out, you take appropriate remedy in accordance with law at page 457, paragraph 5.
Yes.
That remedy, my lord. Thereafter, my lord, what has happened that my client was advised to file a civil suit, my lord, which is at page 460, my lord. Civil suit. Civil suit was filed, my lord. In civil suit, my lord, we prayed that for setting aside of the direction and also direction to renew the lease, my lord. That is because renewal of lease is going to expire in 26, my lord. But that lease will be renewed in as it is being done in all cases, my lord. Thus, my suit was pending for 2-3 years and ultimately it came to be dismissed as withdrawn. If you also will see page 461 at the bottom, 462 at the bottom. This order, my lord, was passed while considering the petition filed by the plaintiff and submissions made by the learned counsel. Court has observed that there was firstly an unnecessary delay of due process of law on the part of plaintiff and secondly learned counsel and plaintiff did not satisfy the court that there is any formal defect in the claim. Neither did he in his petition for withdrawal, nor during his submissions satisfy this court that there exists sufficient ground for allowing the plaintiff to issue a fresh suit for subject matter of suit or part of claim. Hence, in view of development, this court is inclined to allow the prayer of the plaintiff to withdraw the instant suit, but is not inclined to allow the liberty to file suit afresh on the same subject matter. Instant suit stands disposed of from withdrawal. So, in 22, petition was moved for withdrawal of suit with liberty to approach afresh. The learned civil court, my lord, the learned assistant district judge, said that I will permit you withdrawal, but I will not grant you permission to approach your court afresh, my lord. But my lord, your lordship is aware that so far as the remedy of civil suit and remedy of writ court is concerned, my lord, the remedy of writ court is concerned, my lord, this is independent remedy and I am supported by case law on this point, my lord. But the issue before your lordship in my humble submission is that appellate authority pass clear and categorical direction, that my plan will be considered. That plan was not considered.
No, but you are rewinding it back to 2019 because now you have gone, you file contempt, you file a suit. What will be what bearing will the suit have on your present?
This suit will have no bearing because will not be so far as the question before your lordship is that there is a duty on the part of both to examine and pass the order in accordance with law. This is a continuing duty on their part. And continuing wrong is taking place, my lord, on the part of the court in not granting me permission, my lord. Therefore, cause of action is not obliterated, my lord. Cause of action has not vanished. So, if there is a cause of action in my favor, court is bound to consider the order of the appellate authority and consider the material and grant permission, my lord. Board is in teeth of the order of the appellate authority. Now, in the meantime, rather than approaching your lordship, I approach the suit and I refuse the suit, my lord. That will not extinguish the cause of action, my lord, because I am supported by case laws on this point, even recent judgment of the Honorable Supreme Court on this point, judgment of the Honorable Supreme Court on this point, because withdrawal of suit, my lord, is no bar in instituting the legal petition before your lordship, because I have a subsisting cause of action before your lordship. That is the issue, my lord. And therefore, related notice, I am praying for notice.
Yes, Mr. Mahanta.
Yes, I shall give the counter. Later
What is your objection to the immutability? One delay or what objection you will file? Anyway, heard Mr. A. Kumar, Leonard Senior Counsel, on behalf of the petitioner, assisted by Mr. N. Khera and so and so, sub-issue notice. Mr. S. P. Leonard Senior Counsel is present, except notice with so and so. On behalf of the respondents, who look for the notice call for.
sole respondent, yours.
Yes, no, just after
4 weeks.
4 weeks for instructions or affidavit. Yes.
Obliged, my lord.
I'm sorry, yesterday I could not appear. I went to.
Daily list, item number 1.
You've approached them?
Yes, Lordship, I have approached them. I have met on 6
this is the copy. I even make a statement. I've been apologize for if there is any mistake in the last.
No, I don't do apology. We just say that counsel submit that nothing remains consideration. The contempt seems closed.
Well, highly obliged.
What you do there is what you do.
My lord.
Item number 2.
I'm entering appearance on behalf of the respondent, but this matter has already been disposed of.
In view of the order passed in.
The matter has been disposed of, but my lord, there is contempt, my lord, because the contempt is filed with regard to the stay order passed by the server court. My lord, at that point of time, my lord, they have come and with a bulldozer.
His possession was never disturbed. I've taken instructions. They can't say that possession was ever disturbed.
My lord, may kindly see the photographs. They came and they came with a bulldozer. They cut
But
all the trees.
that's not your land.
My lord.
It's someone else's land, correct?
No, my lord, that is my land.
You've put photograph here.
My lord.
In this contempt.
My lord, my lord.
This is just from newspaper.
Newspaper, correct. My lord, on the next page, my lord, may kindly see.
How will you know by looking at this thing, at the picture? You file a short affidavit then?
A copy may be made available because the contemner is not in station anymore. He's been shifted to Shillong. He's been transferred to Shillong.
You changed the. When did it happen? This your alleged
in the month of January, my lord.
January.
He was there at the time.
Perhaps I'll take instructions.
Yes,
a copy may be made available. So we'll file a reply.
Yes, sir. MS Ardata submits that though the main writ petition has since been disposed of, the petitioner still has issues, as it is alleged that during the subsistence of stay orders in Paris court, demolition had taken place.
My lord, they have cut down the trees, and my lord, and they dig earth also from my land.
Some destruction of property had happened because of the felling of trees. Mr. SN submits that a reply will be filed. That however, a copy of the contempt application be made over. Oh, you today first time entering a
first time.
So Mr. SN is entered the appearance on behalf of the respondent. Such notice is complete. Next, what is submission? Mr. SN. Yes. Yeah. Copy be, but however, a copy is yet to be served upon a said respondent. So I should take steps accordingly for service of copy. Just after 3 weeks. Yes.
Item number 3.
Please, Your Lordship. My Lord, I have taken steps upon the respondent, still awaiting for the response, the report from the return of the ED.
How many respondents are there?
Only sole respondent, one.
No. Has been received. Office note indicates that the sole respondent has since been served. But however, there is no appearance on their behalf today. And just after 2 weeks for appearance. They've been served with the office note.
4.
May I please Lordship? Lordship, during the course of the day I will file my affidavit, Lordship.
You already filed.
On 16th of July.
You have to Marak Legal Counsel for respondents number
6 and 7.
Submits that after will be filed in the course of the day. Just after 2 weeks for rejoinder if any.
Much appreciated.
5.
Lordship, on item 5, I'm filing the affidavit in the course of the day, Lordship.
Then interim prayers hosting up today.
Lordship, just been signed today, Lordship. There's some personal difficulty. It will be filed today, Lordship. It can take up next week.
Not a contest.
Yes?
Can be taken up next week, Lordship. Interim prayer. I'll serve a copy to my.
Copy?
No, Your Lordship. It's in the process of.
Mr. Emmanuel Pure, Learned Counsel for Response 1 and 2 submits that the affidavit on behalf of these respondents will be filed in the course of the day. Upon this matter, after 1 week for consideration of interim prayer.
Much obliged.
6.
As per the last order, my lord, senior was supposed to take instruction regarding the managing committee, my lord, that what instructions? Constitute a managing committee whether they are agreeing with it.
Yes, who's supposed to take instruction?
And for the state, my lord, may I just make a very small request, my lord? If lordships, if it appeals to lordships, matter may be disposed of by directing the state to examine the rival claims and, if necessary, to constitute a regular SMC. Yeah, lord. We have no problem. We will consider the rival claims. Yes, others is a never-ending dispute.
Janapriya, all these schools, Mola Kandi, Ketadoa.
Probably my lord has also handled them.
Those names, you know, whenever I see this thing, I know I'll be either one of those.
And I'm confident, my lord, no matter what decision we take, one of the parties will come back.
Of course, yes. It's like, you know, what do you call it? Vicious cycle.
So what my lord has pointed out once in a Nokma matter is a bouncy case where it goes bounce and come back.
Your Lordship, this matter is connected with item number 8.
Yes. So common order will be passed.
Yes, when the matter is taken up, the incident petition has been filed. The incident petition. So who are the people who filed it?
I have filed it. Well, there's two petitioners.
I filed
Who's Anwar Hussain?
writ petition.
Anwar Hussain.
Lordship.
He's one of the parents, my lord. In WPC 420, he's one of the parents. Parents, isn't it?
Yes, the incident petition has been filed by one of the parents of the students of Janapriya. Janapriya, correct?
Yes, ma'am.
Janapriya Higher Secondary School. Jana JNAPRIYM Higher Secondary School, comma, Bholar BHOLAR BHITA. Being aggrieved with a resolution dated 13/7/2024, whereby a special managing committee has been approved. Submissions of the petitioners. You also is.
Your Lordship, I'm against non-approval of my managing committee, which was conducted at 10 days.
Okay, we'll address your thing separately. No. The submission petitioner is that the said approval of a special managing committee without the constitution of a regular managing committee is illegal, and therefore the same is liable to be interfered with by orders of this court. Mr. S.N., learned government advocate, however, has made a concession and submits that as the dispute is ongoing, the respondent, that is respondent number 5. Respondent number 5 may be allowed to examine the.
No.
1 to 4.
We are 1 to 4. But the concerned respondent is director.
Yes. Be allowed to.
3 and 4 will take a decision.
1, 3, and 4 may be allowed to re-examine the matter and take appropriate steps for reconstitution of a regular managing committee at the earliest.
Can a deadline be given, my lord? Maybe within 4 months or 3 months? First, we'll examine the rival claims.
Dr. N. Mozika, learned senior counsel, principal 5, submits that as an interest of the school and students, he has no objection to the suggestion made by the government, by Mr. S.N. In view of the concessions made by the parties, this writ petition is disposed of by directing the respondent 3 and 4 to examine the matter by giving adequate opportunity to both the parties and to take appropriate steps thereon for constitution of a regular management committee. It is expected that the entire exercise should be completed preferably within a period of
2 months, my lord?
2 months from the date of receipt of this order by the respondents 3 and 4.
In the meantime, the status quo will continue.
Yes, as ordered,
you will also be included in this, no?
The matter is ordered. It's ordered accordingly.
Against my
However,
school managing committee, which
provided
I
during the
general meeting.
Still further orders are passed by from 3 and 4. Status quo shall be maintained as on today. Yes.
Will this may include item number, the next item as well?
This is number 7, number 6. Okay, then this C number.
Sorry, 8. 8.
Yes.
6 and 8.
Number 8. Number 8 WC 285. Huh?
I will go. So they will also be heard.
This SG Estamur is a MLA.
Yes. Excellent.
Yes, yeah, they also this matter.
No.
It concerns the same school, so they may also be heard, my lord.
Yes. This incident petition is related to WC number
420 of 24.
Since been
285, Your Lordship.
the incident petition is related to WC number 420 of 24 and concerns the constitution of the school management committee of Janapriya so and so. Stop. In view of the directions which have been passed in WC 420 or so and so, this petition also stands disposed by directing respondents to also here to consider the grievances put forward by the petitioners in instant petition. Stop. The matter accordingly stands closed in this program.
Hello.
Hearing 7.
Lord, in this matter, I had taken some time to get some insight on that amended provision of the guidelines. Nothing fruitful has come from the department, even they're not really aware. This matter may be disposed of, my lord. The only thing is either they may be directed to approach the NGT or even if lordships...
Now, but how can we pass different directions if suppose it goes against the, the stipulation that have been given for riverside construction?
No, so what they have also said, these are prospective in nature, the guidelines from 2023 and 24. So that's one aspect. And number two, even if any concession is given to them, any kind of protection, it should be a one-off case, my lord, should not be a precedent for any other of the parties, because the rest of the people
why should we put them to the headache of going to NGT and all?
No, I'm saying even if your lordships grant them any relief today in writ jurisdiction, let this be a one-off case, should not act as a precedent for anybody else. Otherwise, there are a lot of fence sitters. They will try and take advantage of this.
That is the exact consideration, because it won't be one construction. It will not be one construction there only. It will be construction all over the place. Up to Amkra also.
Lordship.
So, Mr. Suna,
yes.
What do you propose?
My lord, the arguing counsel is Mr. Someone, so might say something.
Your counsel?
Arguing counsel. Right from the
someone?
Yes. Through oversight, he...
Through oversight?
Unable to present, Your Honor. May I have it next week, my lord?
But you've heard the submission, we've heard the suggestions. You convey them to him, then we'll dispose of next week.
Yes.
Yes, Mr. S.M. Suna.
Lordship may have it next week.
Yes, expresses his difficulty in conducting the matter due to the absence of the arguing counsel. List after 1 week.
Obliged, my lord. Obliged, my lord.
9.
This is the contempt matter. We had already placed a judgment of the Honorable Division Bench in this matter that contempt may not be maintainable in these kind of proceedings. Besides that also, the other factor is substantial payments have been made to the GST by us. These proceedings can be closed.
Dr. Mozika, has the list changed or has the dimension changed of the case?
Well, it is a fact that they paid a substantial amount. I think 24 crore rupees has been paid with him.
24 plus, 24 plus 6. Well, that's there in that other CGST matter which my lords are hearing in the division bench. Substantial payments have been made. Well, that otherwise also well is
closer for the time being then. Yes, as submitted by
leaving the department to pursue.
Yes, Mr. K. Paul, we can't. This is a contempt matter. You can do whatever you want. We can't pass in direction. Mr. K. Paul, Learned Senior Counsel, on behalf of the respondent, submitted that since the institutional incident matter, substantial payments have already been made to the petitioners, amounting to approximately rupees 30 crores.
How much? My lords, 24 crores. Well, it's
24 crores. So, in review of the matter as the in review of the matter in the considered view of this court, nothing remains for consideration presently. The matter is
inbuilt that was there in the order itself.
Well, may I just point out? I pointed out a judgment of the Honorable Division Bench, my lords, where we challenged the maintainability of this matter. My lords are recording payment. That, well, it's maybe a
judgment is there.
Maybe as if we are submitting to the that they made a duress.
That it's an issue of law.
We shouldn't make those observations in case the court says now that how in contempt jurisdiction you got it by allowing.
This order is here.
Because the law is settled, my lords. And we placed that judgment before my lords also. So, in that view of the matter, my lords,
what does it say?
Well, it's para 6 if my lords can have a look. Same order. Contempt jurisdiction cannot be invoked to enforce payment, particularly against a private petitioner. Petitioner will be entitled to force his claims.
Then we'll take it on this way that when the matter is taken up, Mr. K. Paul has drawn the attention of this court to an order dated 20/09/2023, passed in contempt case number 1 of 2023, wherein it is observed that ordinarily contempt jurisdiction cannot be invoked to enforce payment petty against a private petitioner. Stop. However, it also has observed that the petitioner will be entitled to enforce his claim against respondent in accordance with law. But in view of this order of the division bench, the incident contempt is closed and disposed of.
And also with the 24 crore payment, maybe.
No. Yes, I'll just write also.
Just that, yes. That we.
Mr. K. Paul has also submitted that nothing suffices in view of the fact that payments.
Otherwise, also 24 crores.
Otherwise, not made out. Otherwise, also there is no contempt, no has made out as over 24 crores payments already been made to the petitioners.
14.
Highly obliged.
This lordship is regarding recovery of excess payment to the petitioner,
yes,
lordship, and in fact, your lordship has already passed a judgment in another case similar to this, your lordship.
What is the judgment?
And I've got some Supreme Court is also.
And make out the parties also. Yes, you see the judgment.
Yes, my lord, but here it seems like some of the benefits were already released. But
what recovery? What they pray here?
No, they are seeking to recover
Excess
from excess payment, my lord, from the year 2007. And the Supreme Court is very much clear, my lord, since in this judgment also Lordship has already referred to that judgment, my lord.
Masi?
Rafiq Mish, my lord. If Lordship comes to the, my lord.
Where's the impugned?
The impugned letter is at page 37, my lord, annexure 10. Here they are seeking to recover from the year 2007, my lord. I retired in the year 2024. More than a decade, my lord. After 16 years. And they themselves have admitted, my lord, that it is not the mistake of the petitioner, but rather by the mistake of the BDO and the...
Page 37, annexure 10.
Yes, this is the impugned letter, my lord.
Yes, yes.
They're seeking to recover from the year 2007. And the amount is coming to 10,73,496, my lord. If Lordship comes to page 41, that is the total amount which they are seeking to recover, my lord. 10 lakhs.
41.
10,73,496. Yes.
Deduction at what rate from your pay? Have you started deducting?
No, not yet.
Not yet, my
Lordship,
lord.
we are still processing the
He's already retired, my lord.
calculation. He is retired in February 2024, Your Lordship. And then while processing his terminal benefits, etc., it was found that there was an error in calculating his monthly payments, Your Lordship, with effect from 1st January 2007 till the date of his retirement. And
Who
this
is responsible for that?
It is their responsibility, my lord.
No, it was the officer's responsibility, Your Lordship.
Then
There was an error. So, Your Lordship, now they have supposed to recover those amounts which had been given in excess to him. And I would also like to draw your attention to the undertaking, Your Lordship, which the...
Something been given that in
Yes.
case, where's that?
we have annexed it in our
There's my lord, but I will submit, my lord.
Annexure H and I, Your Lordship.
Let them submit first.
To my
It
affidavit.
was not known to you at all. Then totally, if it's with them, then maybe, yes.
So he has signed it, Your Lordship. Once he has given in the year 2009.
Where is that?
At
That is,
page 20 of my affidavit, Your Lordship.
By number 2.
The petitioner has given an undertaking.
Your respondent number?
I am the respondent one. You're correct, Your Lordship. Affidavit of respondent number 2.
Number 2.
What paragraph?
This is at annexure of H, Your Lordship, page 20.
Annexure?
H, page 20. This is the undertaking given by the petitioner, Your Lordship.
See, Mr. Moomin.
So when he has been put to notice, Your Lordship, it becomes...
Lordship, let her submit first, my lord. Let my senior submit.
You're the petitioner, you submit first.
No, then I'll submit, my lord. Since she was already submitting, my lord, I was just
yes.
giving opportunity,
If you
my
don't
lord.
want to submit, then you've closed your...
Lordship, what has happened, my lord?
Let's see. I hereby undertake...
Lordship.
Any excess payment
2009.
due to result of incorrect fixation of my pay or any
So you
excess...
recover from 2009 onwards?
No, my submission, my lord. My submission.
I also, Your Lordship, he has given. In the year 2024 also he has given.
No, in regard to your undertaking, if I may be permitted to submit, my lord.
Okay, you submit your case. You appointed when?
I was appointed...
Gram Sevak.
Yes. Then thereafter, my lord, I was promoted to senior Gram Sevak and retired in the year 29/2 of 2024, my lord.
Retired on?
29/2 of 2024. Now they say that I have given an undertaking, my lord, that the money can be deducted. Here my submission before this honorable court is that, my lord, in view of the judgment by Rafiq Mishk, my lord, 2015, the Supreme Court has held that a grade 3 employee, my lord, the deduction of pay overdrawn.
That is a thing. I don't think is a precedent. Yes, anyway, let's see.
The Lordship has dealt with that judgment also in the...
There's a grade 3 employee, my lord.
Clear a copy of this one.
My lord.
What's the thing? Any you? I just tend to print out
and Rule 73 also says, Your Lordship, that any excess payment can be recovered by the government, Your Lordship, at the of the Meghalaya Civil Service Pension Rules.
High Court,
my submission is, my lord, they have...
Okay, how do you say this Rafiq Masi?
Yeah, because
case will apply to you?
I'm a grade 3 employee, my lord. It says that if the petitioner has not done any fraud or misrepresentation, my lord, and if it is solely the mistake of the authorities, my lord, then the petitioner should not be made liable, my lord. It is not my fraud or misrepresentation by the petitioner, my lord. And herein, my lord, if lordship comes, I've given that compilation of the judgments, my lord, page 15, my lord, if lordship comes. It says that, if I may be permitted to read, my lord, it says that it's not possible to postulate all situation of hardship which would govern employees on the issue of recovery where payments have mistakenly been taken by the employer in excess of their entitlement. Be that as it may, based on the decision referred to here and above, we may, as ready reference, summarize the following few situations wherein recoveries of the employees would be impermissible in law, my lord. So recovery from the employees belonging to class 3 and class 4 service, my lord. I belong to class 3 category, my lord. Recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. Recovery from the employees where the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. The undertaking was made in the year 2009, my lord. They're seeking to recovery after a decade, my lord. Recovery in issue where an employee has wrongfully been required to discharge.
The only consideration you have, Mr. Moment, is that other things, leaving everything aside, is that the recovery is being sought to be made
from 2007.
Not 2007. After you've retired.
Yes.
That's the only thing.
Yes.
So whether that's permissible or that will
that is not permissible in law. That is my humble submission.
Whether it's now the thing is that only thing that goes against you is that fine you made undertaking in 2009. So any recovery also this court will hold that you made 2009 onwards. Suppose the case goes against you, but you have to show that you know that is a bona fide mistake on the part of the respondent, correct?
Yes.
Yes.
It was their mistake, my lord, and there was a revised pay scale also was already made, my lord. Financial upgradation he got, my lord. During that time also they did not detect that mistake. Only after I retired, my lord. They're seeking to recover from year 2007, my lord. And that is why, my lord, my humble submission would be, my lord, that the petitioner would suffer irreparable loss and injury, my lord. He's a grade 3 employee.
How much pension is he drawing now?
Now, basic pay, my lord, he was getting 69. But they are seeking to reduce that also.
No. What is his pension now that he's drawing?
Pension is not receive any pension, my lord.
Not yet released.
Not yet released, my lord. Even his gratuity, leave encashment and all has not been released.
Suppose as per his last pay certificate, I'm not saying you're getting in your hand.
Yes.
I'm saying as per the last, suppose in normal circumstances, for the scale of pay that you are drawing and your last pay certificate, what would be the pension?
No,
monthly pension? Forget your gratuity, forget other things. Your monthly pension, how much amount would you entitled to?
I think that the state government will be the better position to answer that, my lord. But
seek instructions on that.
Because then, like, if you know the amount of pension drawn, you know, it's it is very less, and for recovery 10 lakhs, then we
No, the Supreme
on the
Court,
ground
yes,
equity.
the Supreme Court has said that because they can be recovered in equated monthly installments spread over a period of several years. This is another judgment, Your Lordship, where when the petitioner had been put to notice, Your Lordship, even this, what my friend has said about Rafiq Masih, Your Lordship, that will not apply here because he was put to notice, Your Lordship.
He was put to notice, but the money has to be recovered when he was still in service, my lord.
Therefore, he is bound to make the payment. And Rule 73 of the Meghalaya Civil also says.
So that you're aware. I think
Yes,
the only
Your
thing is that, you see, these kind of cases only have to be balanced on equity. That's all.
Yes, sir. It can be done, Your Lordship, by equated monthly installments.
The financial loss has been caused to
petitioner,
the respondents. That's all.
It can be spread over to a few years, Your Lordship, as a recovery can be made in that way.
So whether,
but then how much pension
drawing
is
of
to
a certain
get?
amount, will, because you see, it'll be harsh. Suppose he's drawing a pension of, maybe 30,000, you withdraw 10,000. It'll be very harsh. How much pension will you be drawing? You'll be drawing.
That I have no idea, my lord.
Can you find out?
We'll find out, Your Lordship, from the department.
Hearing on a query of the court as to the pension, as the amount of pension that will be permissible or payable to the petitioner as per last piece certificate, MST Yangi B praise will out to compute the amount.
Yes.
This after 1 week. Otherwise, nothing.
After 1 week, Your Lordship.
1 week. Just calculate. Just them to calculate.
Lordship.
She's there from EG.
Yeah, you can also.
Yes, how much? Suppose leave things aside. Forget about recovery. Suppose on his last pay that he's drawing, what would the permission payable to him monthly?
Maybe 40.
Then
just guessing, Your Lordship,
50,000.
could be 40 perhaps. 35, 40.
That's what the quote on 30,000 something. If it was pension also, then
no, because of the delay, my lord, the bank has already given us notice also, and the bank, my lord,
taken loan, Your Lordship.
They have taken loan, my lord, and because
that is not the concern of the department, Your Lordship.
No, but because of the lapses only, I had to suffer.
What amount the loan?
10 lakhs was taken as a loan, my lord, but for construction of the house, or for treatment, my lord. I've also enclosed the medical certificates, my lord.
This is fine. Oblige, Your Lord.
Very fast way.
Hello, Brishma.